The International Criminal Court is now in session.
Good morning, everyone, or good afternoon, everyone. This is the pretrial session of the case, the prosecutor versus Mr. Graves. So my name is Kazushige Doi. I'm today presiding this session, and collaborating with me, my colleagues, Judge Worsnop and Judge Harbour are joining this session. Before the hearing, so I will ask you both to introduce yourself very briefly and to indicate the allocation of your pleadings times. So first, for the prosecution, so you have now the floor, please.
Good morning, Mr. President. My name is Ekaterina Fakirova, and I will be the first speaker for the prosecution, and I will speak for 15 minutes. And Mr. Fikri Faruqi, my co-counsel, will be the second speaker for the prosecution, and he will speak for 10 minutes. Thank you.
Defense counsel, please.
Good day, Judge President and your honors, and may it please the court. Am I audible? My name is Bridget Matoni, first counsel on behalf of the defense. I will be speaking for 10 minutes on prayer 1 and 6 minutes on prayer 2. My co-counsel will then take a further 9 minutes to address prayer 3, Alyssa Jatuli.
Thank you. Then we are moving to the hearing. So then first, prosecutor, so I'll give you the floor. So please.
Good morning, Mr. President, your honors. May it please the court. For 6 years, a single individual transformed the state of Hanatun into a coordinated machine driven by discrimination. And predictably, this environment of hatred culminated in acts of genocide perpetrated by the gears of the Hanatun apparatus, to which Mr. Graves simply turned a blind eye. The prosecution today will make 3 submissions. First, that the case is admissible. Second, that this court has jurisdiction. And third, that Mr. Graves is criminally responsible for both counts of genocide pursuant to Article 28A of the Rome Statute. I shall address the first 2 claims, and my co-counsel will address the last. Turning to our first argument, we submit that the case is admissible, and we will focus on the contentious issues of complementarity solely. Your honors, pursuant to Article 17(1)A of the Rome Statute, a case will be deemed inadmissible if it is being investigated or prosecuted at the domestic level. However, it is not sufficient merely to assert that investigations are ongoing. And from the Kenya Appeal Judgment, paragraph 2, tangible proof to demonstrate that a state is actually carrying out relevant investigations is needed. And furthermore, there must be evidence with probative value and a sufficient degree of specificity. And this evidence may take the form in interviewing witnesses or suspects, collecting documentary evidence, or carrying out forensic analysis, as it was elaborated in the Gaddafi admissibility decision, paragraph 55. Your honors, this is the level of specificity required. And from case fact 18, we merely know that a military court was established and that it will finish its investigations later on this year. We only have assertions that investigations are ongoing. We have no information on, for example, when the investigation started, on any of the concrete and progressive steps that the Republic of Hanatun is taking, on who the prime suspects are. Therefore, there is no concrete, tangible, and pertinent evidence that proper investigations are currently ongoing in Hanatun. And consequently, this case should be deemed admissible. Moving on to our second argument, we submit that the case against Mr. Graves falls within the jurisdiction of the court, and we'll focus on material jurisdiction pursuant to Article 5 of the Rome Statute. Your honors, there are 2 counts of genocide that will be addressed. First, genocide by killing under Article 6A, which was perpetrated by the NDS and SPG. And second, genocide under Article 6C, which was perpetrated by the police department. Turning to the first crime, there are 2 contextual specific elements that need to be met. First, that members of a protected group were killed, and second, that those killings were carried out with genocidal intent. As for the first element, we see that it is fulfilled because on the night of the 15th of July 2019, 200 Castilian men were shot dead. And as for the second requirement of genocidal intent, the Akayeshu judgment and the KSM and Rosindana one have provided us with 4 factors from which genocidal intent can be inferred. The first factor stems from the Akayeshu judgment, and it is the deliberate and systematic targeting of victims pursuant to their membership of a particular group while excluding members of other groups. The second factor is from the same judgment, and it is the targeting of children and pregnant women who would naturally not have been among the fighters. The third factor comes from the KSM and Rosindana case, paragraph 93, and it is the use of the derogatory language towards members of the targeted group. And the final factor is again from the KSM and Rosindana case, and it is the cruelty with which the attacks were carried out. Your Honors, in our case, all of these factors are clearly present because we know in case fact 13 that upon learning that Mr. X was of Han ethnicity, the NDS and SBG did not proceed with the commission of the crime, while at the same time, they executed 200 Castilian men, only 2 of which were CNF members. And at the same time, they were targeting pregnant women and abusing them, which the pregnant women would naturally not have been CNF fighters. Furthermore, in case fact 13, we once again see that the SPG officers were chanting Castilians are cancer, therefore using derogatory language. And finally, the cruelty of the attacks can be witnessed from the fact that those attacks were carried out in the middle of the night. The NDS and SPG barged into the homes of Castilian people. They apprehended and arrested the Castilian men and forced them to admit that they were part of the CNF. And if they refused to do so, they were being shot on the spot. And while this was ongoing, their pregnant wives were begging for the lives of their husbands, and they were getting kicked in the stomach, and SPG officers were heard chanting Castilians are cancer. Your Honors, it is clear that the acts on the night of the 15th of July 2019 were carried out with genocidal intent. Moving on to the second count of genocide. Under Article 6C, there are once again 2 specific elements that need to be met. First, that there was infliction of certain conditions of life upon the protected group, which were calculated to bring about their physical destruction. The second specific element is that this infliction was carried out with the requisite genocidal intent. As for the first condition, we see that it is fulfilled because from the elements of crimes, we know that certain conditions of life encompasses deliberate deprivation of resources indispensable for survival, such as food or medical services. And in case fact 15, we have the police's actions, which were namely the deliberate deprivation of food, and they resulted in the famine. Therefore, the first specific element under Article 6C is fulfilled. Moving on to the genocidal intent, namely the second specific element, we would like to draw an analogy with the KSM and Rosindana case. And in that case, the court found that genocidal intent was inferred from the deeds and words of the perpetrators, and it was further demonstrated by a pattern of purposeful action. And this pattern, Your Honors, included the gathering of Tutsi refugees and in places where they were not allowed to leave those places, and furthermore, those structures were surrounded by Hutu assailants. And the Tutsis inside those structures were denied food, medicine, and sanitary facilities. Furthermore, in the KSM and Rosindana case, the use of roadblocks was present. And at those roadblocks, those who identified as Tutsis were either arrested or killed. And some of the Tutsis that were arrested were later taken to places where they will be subsequently injured, mutilated, or some of the women will be raped. Your Honors, all of those factors and this exact situation was happening in our case as well. We have the entire province of Castilla being closed off and the people of Castilla being stuck inside. And this was happening from the July 2019, possibly up until this moment. And not only that, but the people inside the province were starving because the blockade was not the only factor, but there was also the forceful shutting down of local businesses, which we know from case fact 4 that they were largely agricultural. Therefore, forcing them to close down removed the possibility of Castilians to utilize their natural resources and sustain themselves from it. Therefore, the blockade, together with the closure of businesses, led to the starvation of the people in Castilla due to the restriction of food sources, both from the inside and from the outside. Furthermore, we know from case fact 14 that the use of roadblocks was also present. And namely, we have Castilians that were trying to flee the region that were, once reaching those roadblocks, were either arrested or killed on the spot. And some of the girls that were arrested, some as young as 13 years old, were later sent on to places where they will be subsequently raped. Your Honors, all of these factors taken together were concluded as being genocide by the ICTR. And given the killings and the arrests of the Castilians at the roadblock, the context within which those killings and arrests occurred, namely the blockade and the starvation of the entire province of Castilla, it is clear that the Federal Police Department possessed the intent to destroy the Castilian ethnic group. Moving on to the final element, which is common for both counts of genocide, namely the contextual elements, we submit that both counts of genocide took place in the context of a manifest pattern of similar conduct directed against the Castilian ethnic group. And this pattern began with the violent suspension of the Castilian parliamentary activity and the halting of the federal payments, which then led to the introduction of the counterterrorism campaign. This campaign then escalated into the various violent acts of the security divisions directed against Castilians. In case fact 12, we see the killings of Castilian men. In case fact 13, the violence against pregnant women. Case fact 14, the forced labor and the sexual exploitation of young girls. And in case fact 15, we see the starvation of the entire province. Therefore, the contextual element is fulfilled. As for—
Excuse me, Counselor. Could you maybe inform us about some jurisprudence about the definition of the manifest pattern that you mentioned?
Yes, Mr. President. According to the Al-Bashir arrest warrant decision, paragraph 124, this contextual element was described as the completion of the crime of genocide when the relevant conduct presents a concrete threat to the existence of the targeted group. And we can see that in our case.
Thank you. Yeah, please proceed.
Moving on to other questions of jurisdiction, we submit that this court can exercise jurisdiction over the genocide according to Article 13b, because we have a United Nations Security Council referral. And pursuant to a United Nations Security Council referral, regardless of the fact that Hanatun is a non-state party to the ICC, the court can still exercise jurisdiction over both counts of genocide, pursuant to this United Nations Security Council Resolution 2022. And the temporal jurisdiction of the court is also fulfilled pursuant to Article 11.1, because according to the Abu Garda decision, the court can, the United Nations Security Council referral can backdate the temporal jurisdiction of the court to any moment in time after the 1st of July 2002, which is namely the date of entry of the Rome Statute. And in the present case, the United Nations Security Council Resolution 2022 refers the situation in Hanatun to the court as of the 1st of March 2019. Therefore, the court has temporal jurisdiction. If there are no further questions, Your Honors.
Counsel,
yes.
Thank you for your submissions, Counsel. Could you please remind the bench which party has the burden of proof on the jurisdiction issue, and also what the standard of proof is at this stage?
The standard of proof at this stage is reasonable grounds to believe, pursuant to Article 58 of the Rome Statute, and this standard of proof was elaborated in the case law of this court, namely as being, for example, in the Nataganda case, as reasonable grounds to conclude that that the crime has occurred, and those reasonable grounds can exist even where there may be another reasonable conclusion to the contrary. And as for the burden of proof, for the admissibility of the case, it is the defense who bears that burden of proof, and for the jurisdiction, it is the prosecution.
Thank you.
If there are no further questions, I will now yield the floor to my co-counsel, and this will conclude my submissions. Thank you for your attention.
Good morning, Mr. President, Your Honors, may it please the court. My name is Ricky Faruqi, and on behalf of the prosecution, I will demonstrate that Mr. Gravis is criminally responsible for both counts of genocide pursuant to Article 28A of the Rome Statute. To establish command responsibility pursuant to this article, 4 requirements must be fulfilled. First, a person must have effectively acted as a military commander. Second, the person had effective authority and control over his forces. Third, the person should have known their forces were committing a crime. And lastly, the person has failed to fulfill their duty to repress. Now, Your Honors, moving on to my first argument, Mr. Gravis was effectively acting as a military commander for the security apparatuses of Hanatun. Now, this court has defined the term effectively acting as a military commander as seen in paragraph 409 of its Bemba confirmation of charges decision, which refers to any person who has de facto control over quasi-military forces, which includes regular governmental forces, such as the police. We can see this is clearly the case, Your Honors, where in Fact 11, Mr. Gravis has de facto control over regular governmental forces being the security apparatuses of Hanatun, which includes the NDS, SPG, and police. Thus, we submit that Mr. Gravis was effectively acting as a military commander for the security apparatuses of Hanatun. Turning to my second argument, Mr. Gravis had effective authority and control over his forces. Now, this court has defined several factors for indicating effective control, as seen in its Bemba 2016 trial chamber judgment, paragraph 188, 3 of which are especially relevant for our case today. The first factor is the position and actual task of the commander. The second is his power to issue orders. And the third factor is his representation of the ideology in which his soldiers adhered to. Applying each of these factors to the case, Your Honors, we can see for the factor, this is obviously the case where Mr. Gravis was commander-in-chief of the security apparatuses of Hanatun, as seen in Facts 1 and 7. Some of the actual tasks that he carried out can be seen in Facts 11, where he made policy objectives, being the counterterrorism campaign. For the second factor, we can see that this is also fulfilled, where within such counterterrorism campaign in Facts 11, it included orders. For the third factor, Mr. Gravis embodies anti-Casterian ideology, as we can see on Facts 13, where on national television, he called the Casterians cancer that must be eradicated off the map. This ideology can also be seen in his actions, as seen when reducing financial federal transfers to Casteria, as seen in Fact 6, and not giving any Casterians any governmental positions, as seen in Fact 7. Such ideology were clearly adhered by his soldiers, as they said this same exact term while kicking Casterian pregnant women in the stomach in Fact 13, saying and chanting out, "Casterians are cancer." Thus, we submit that Mr. Gravis had effective authority and control over his forces.
Councillor, excuse me. You mentioned the statement of Casterian cancer by Mr. Graves. Do you mean really that this statement is addressing the whole people of Castilian? Basically, the campaign is addressing only the terrorists, against terrorists. That's why, could you maybe support your argument or your understanding about this statement?
Mr. President, the statement "Casterians are cancer" that was chanted out by his subordinates were were meaning Christians as the ethnical group. And we can see that these soldiers, again, adhered to the ideology in which Mr. Gravis represents, this anti-Casterian ideology. And with all the light of these factors together, we conclude that Mr. Gravis had effective authority and control over his forces. Now, turning to my third argument, Mr. President, and your honors, Mr. Gravis should have known that both counts of genocide were being committed by the security apparatuses. Now, this should have known standard requires an active duty by the commander to secure necessary knowledge of the conduct of his forces, regardless of the availability of information. And this is consistent with the Bemba Confirmation of Charges decision, paragraph 432 to 434. Furthermore, according to the Von Lieb case in page 603, this duty would be violated if the commander receives a report that is clearly on face inadequate, but does not obtain more information. Now, applying these rules to the case, your honors, for the first count of genocide for the killing of 200 Castilian men, we can see that in Facts 11E, it required the heads of all three security divisions to report to Mr. Gravis personally and regularly, but only one has actually done this, being the head of the NDS, Ms. Jolie. And we would say that this one report by Ms. Jolie is on face inadequate, as it only contains a few lines of text messages and reassurances by Ms. Jolie, and it did not mention anything of the NDS and SPG, only about the civilians. For the second count of genocide, Mr. President and your honors, you can see namely the starvation of Castilla as a whole, there are no indications in the facts that Mr. Gravis inquired about the police's conduct. Thus, with this, we can see that Mr. Gravis has failed and should have known that both counts of genocide were being committed by his forces. Now, with the should have known standard being fulfilled, your honors, we can see this triggers the duty to repress, as seen in Bemba Confirmation of Charges decision, paragraph 435. Which turns to my fourth and final argument. Mr. Gravis failed to take necessary and reasonable measures to fulfill his duty to repress. Now, the duty to repress encompasses two different obligations. The first obligation is to punish his forces that has already committed a crime. And the second obligation is to stop any ongoing crime. And we can see that some of the necessary and reasonable measures that Mr. Gravis can have taken are for him to, for example, order the troops to stop the crime, or maybe withdraw the troops altogether. And this is consistent with the Bemba Confirmation of Charges decision, paragraph 500 and 501. And applying these to the case, we can see there are nowhere in the facts that indicates Mr. Gravis repressed the police of ongoing crimes or punished the NDS and SPG from killing of 200 Castilian men, where he had the ability to do so ever since 2019. Thus, we submit that Mr. Gravis has failed to fulfill his duty to repress and take necessary and reasonable measures to repress the NDS, SPG, and police. Unless I can be further of assistance to you, Mr. President, your honors, this closes to submission for the prosecution. Thank you for your attention.
If I could ask one follow-up question. You've presented several arguments about the duties that Mr. Gravis failed to fulfill, the duty to repress. Could you give us your submissions on why you submit the crimes were a direct result of his failure to exercise his duty to repress?
Your Honor, this direct result would concern with causation because of the word as a result of, and this is only concerning for the duty to prevent, not the duty to repress. Duty to repress is, since we're not talking about the duty to repress, Your Honor, the duty to prevent, Your Honor, and only submitting the duty to repress as a separate criminal charge, which is consistent with the Bemba Confirmation of Charge decision, we submit that Mr. Gravis again has failed to take necessary and reasonable measures to fulfill his duty to repress.
Are you submitting that when we're talking about the duty to repress, the crimes don't need to be the result of the accused's failure or omission?
Your Honor, What we're submitting here is the fact that there is no need of a causational element for the duty to repress, and this only applies to the duty to prevent.
Excuse me, do you have authority for that proposition, given the plain wording of Article 28?
Yes, Your Honor, we refer to the BEBA 2016 trial chamber judgment, Your Honor. Now, seeing if there are no further questions.
Excuse me, sorry, yes. I do. Do you have a paragraph number? Sorry if I missed that.
Madam President, we refer to paragraph 439 of the 2016 trial chamber judgment. So, unless I can be further of assistance to you, Your Honors and Mr. President, this closes the submissions for the prosecution. Thank you.
So now, for defense counsel, so you have now the floor, please.
Good day, Judge President and Your Honors, and may it please the court. Am I audible? My name is Bridget Mutoni, first counsel on behalf of the defense, and I will be addressing prayer 1, that the case is inadmissible before this court, and prayer 2, that the case does not fall within the jurisdiction of this court. In dealing with the first prayer, defense challenges admissibility on the grounds of complementarity, and there are 2 arguments to this end. Firstly, that the state is able to hear the matter, and secondly, that the state is willing to hear the matter. Defense affirms that under the complementarity principle in Article 17 and paragraph 10 of the preamble of the statute, states have the primary responsibility to investigate and prosecute crimes. The failure to adhere to these principles render the proceedings not complementary to the Republic of Newton's national law. And it is only if the state is unable or unwilling that a case is deemed admissible. Your Honors, as per paragraph 18 of the case facts, the Republic of Newton is investigating the same case and the same conduct, and prosecution has alleged that there is no tangible proof or probative value to these investigations. However, we turn the Chamber's attention to paragraph 18, which does talk about the inception of the military court, and the primary reason was for the investigations on the alleged criminal conduct areas, specifically starting from the 3rd of November 2015, which was the date that Mr. Gravis took over the Republic of Newton via a coup. And therefore, there is tangible proof that their investigations have started, and there are dates to which this investigation does span over. Moreover, we turn the Chamber's attention to the situation in Libya and the decision on the admissibility of the case against al-Gaddafi, the 2013 decision, whereby in paragraph 36, the wording of Article 17(1)(a) must be understood in the context in which it is applied, and that the national proceedings should be at the same stage as the court's proceedings. If not, then the state should at the very least be preparing to take steps to reach the same investigative stage, and the same investigative stage will be reached by August of 2022, as per paragraph 18 of the fact complex. And therefore, defense does submit that the investigations do have probative value. In turning the Chamber's attention to the issue of inability enshrined under Article 17(3), according to the statute, the court shall consider whether due to a total or substantial collapse or unavailability of its national judicial system, the state is A, unable to obtain the accused, or B, unable to obtain the necessary testimony and evidence, or C, otherwise unable to carry out its proceedings. With regards to the 11th October 2013 decision on the admissibility of the case against Abdullah al-Sanusi, particularly paragraph 265 and 294, Pretrial Chamber 1 found that in relation to Libya's ability under Article 17.3, given that Mr. al-Sanusi was already in the custody of the Libyan authorities, Libya was not unable to obtain the accused, and the ongoing investigation demonstrated the ability to collect the necessary evidence and testimony, and the case was deemed inadmissible on those grounds. Turning to the current case at hand, as per paragraph 17 of the case facts, Mr. Gravis was in the Republic of Hanutin state custody before being transferred to this court, and there are ongoing investigations. Judge President and your honors, the situation in the Republic of Hanutin bears the most similarity to the inadmissible case against Mr. al-Sanusi, as Mr. Gravis was placed under house arrest in September of 2021 and later held in state custody until his transfer to this court. And therefore, as per the indicators of ability under Article 17.3, the state was able to secure Mr. Gravis, transfer him into custody, and is currently carrying out the relevant proceedings. And this indicates a national judicial system that is neither collapsed nor unavailable, and accordingly, the Republic of Hanutin is able. We now turn the Chamber's attention to the second leg of complementarity, willingness under Article 17.2.
Excuse me, counsel. So may I ask you about the investigating body? So this investigation is carried out by the military court, not by the ordinary court. So is it not issue? So in your argument? Maybe so, or what do you think about that point?
Judge President, the issue pertains to the willingness leg on the military court and whether or not it's independent and impartial, or they're shielding Mr. Gravis, Judge President. With regards to the independence and impartiality of the military court, it should be noted that firstly, the Article 17 does not discriminate against which kind of court may investigate the matter, and thus the military court is competent. And secondly, the only indicators in the case fact that would point to a lack of independence and impartiality stem from paragraph 18, which states that a number of high-ranking military officers have recommended Mr. Gravis's release. However, defense contends that the proceedings are being conducted independently and impartially with an intent to bring Mr. Gravis to justice, because case qualification number 3 establishes that these high-ranking military officers have no influence on the military court. And moreover, in the aforementioned case on the decision on the admissibility of the case against al-Sanusi, in paragraph 241, Pretrial Chamber 1 stated that statements made by public officials cannot be attributed to the actual or perceived conduct of the judicial proceedings, and therefore these statements cannot by themselves be regarded as an indication that the proceedings are not independent or impartial. Moreover, in regards to shielding under Article 17.2a, it stipulates that national proceedings may not be undertaken in an effort to shield the accused from criminal responsibility. And as per the standard set in paragraph 106 of the 2003 European Court of Human Rights case of Kuznetsov versus Ukraine on the judgment of merits and just satisfaction, shielding occurs where there are deficiencies in the process that point to a show of bad faith by the state and a lack of proper explanation to the termination of an investigation. Your Honors, as per paragraph 18, the investigation is still ongoing and there is no basis in the facts to point to deficiencies in the process that point to or show bad faith. The military court was primarily established to investigate the crimes in the conflict region from the first coup on the 3rd of November 2015, which indicates serious and effective investigations, and therefore no unwillingness can be gleaned in terms of shielding Mr. Gravis, and by handing him over to this current court, there is no shielding from criminal responsibility on a national or international level. And on that, defense submits that the Republic of Hanutin is both able to under Article 17 and willing. In moving to the second prayer, that the case does not fall. Judge, Your Honor, do you have a question?
I do, yes. Before you move on to the next argument, just a follow-up question on your submissions. What would you say to the in response to the prosecution's argument that there's no indication that the military court in Hanatum has taken any tangible steps, such as investigating witnesses or collecting documentary evidence or any forensic analysis?
Your Honor, with regards to the military court not taking any investigative steps, it should be noted that the investigation will end in August of 2022, and it has been ongoing since the 10th of December, as per paragraph 18. And therefore, with the investigation concluding so soon, it can be ascertained that they have the necessary evidence and testimony to conclude the investigations and to charge Mr. Gravis with the alleged crimes that will fall under the Hanutin's national law, Judge President, or else the investigations would still be ongoing later after. Moving to the second prayer, defense will be making one argument, namely that subject matter jurisdiction is not met as there was no subjective element of specific intent. Defense acknowledges that as per the procedural history, paragraph 1 and paragraph 10 of the case facts, the UNSC has referred the situation in the Republic of Hanutin pursuant to Article 13b. However, for the referral to trigger this court's jurisdiction, it has to be a crime under Article 5 of the Rome Statute, and this would encompass subject matter jurisdiction. And defense submits that the subjective element of intent has not been met to have occurred, and therefore there is no subject matter jurisdiction. Further, the prosecution has alleged that we must take note and cognizance of the perpetrators and the low-level subordinates. However, in Prosecutor versus Omar al-Bashir, on the first decision on the prosecution's application for a warrant of arrest against al-Bashir, the 4th of March 2009 decision, in paragraph 152, the chamber held that the mental state of mid-level superiors and low-level physical perpetrators is irrelevant for the purpose of determining whether there are reasonable grounds to believe that the crime of genocide against an ethnic group was part of the campaign. Judge President and Your Honors, on this basis alone, defense would like to focus on Mr. Gravis's genocidal intent, which there was none. Further, turning to Article 6 of the Rome Statute that stipulates that for the alleged crimes to amount to genocide, Mr. Gravis must have an intent to destroy the ethnic group. However, his intent was to quell the CNF terrorists and their supporters, who are a political group and not a protected group under Article 6. Both Article 6 and the Convention on the Prevention and Punishment of the Crime of Genocide have an exhaustive list of protected groups, which are ethnic, racial, national, and religious groups. And in Prosecutor versus Rutanga, the ICTR judgment of the 6th of December, 1999, in paragraph 57, the Chamber, in applying the general and supplementary means of interpretation found in Article 31 and 32 of the VCLT, found that in a reading of the negotiations of the Genocide Conventions, that certain groups, such as political groups and their affiliation as such, have been excluded from the protected groups because they are mobile groups, which one is not born into, but through individual political commitment. And thus, we established that Mr. Gravis's intent was for the political group. In particular, when looking at paragraph 11A, whereby his counterterrorism campaign was only towards the CNF terrorists and supporters who are a threat to national security and public order. And further, prosecution has relied on the IHRD report as a means to establish the actors reus of the crime. However, defense would like to submit that this IHRD report is not sufficient for us to rely on. Further, as noted in the decision on the prosecution's application for warrant of arrest, with regards to in the decision adjourning the hearing on the confirmation of charges pursuant to Article 61(7)(c)(1, the prosecutor relied heavily on NGO reports and press articles with regards to key elements of the case, and the Chamber was of the view that such pieces of evidence in any way cannot be presented as the full fruits of a proper investigation by the prosecutor in accordance with Article 54(1)(a) of the statute, and accordingly, the decision was adjourned. On that basis alone, defense does not, the IHRD report does not meet the evidentiary threshold, and there was no intent. Therefore, there is no justification on subject matter jurisdiction, and I will now hand over to my co-counsel to deal with the third prayer, if there are no further questions.
Judge President and your honors, am I audible? Magnificent. Judge President and your honors, good day. As my co-counsel stated, I am Alyssa Jatuli. Defense admits that Mr. Gravis is not criminally responsible pursuant to Article 28A or B of the statute. Under Article 28A, defense makes three main arguments. Firstly, that Mr. Gravis did not have effective control. Secondly, that Mr. Gravis did not know. And lastly, that Mr. Gravis did not have the material ability to fulfill the duties. In the alternative, in terms of Article 28B, defense submits that Mr. Gravis is not responsible as a civilian superior. Judge President and your honors, in turning to effective control, the prosecution has submitted that Mr. Gravis's position as a de facto military commander in and of itself is decisive enough to establish effective control. However, prosecution has negated the fact that the 2016 Bemba case at paragraph 188 stated that a formal position of a military commander within a military structure is not decisive in establishing effective control. Rather, it is their position coupled with the actual tasks they carried out. Judge President and Your Honors, while prosecution has presented that as a de facto leader and the creation of a counterterrorism campaign led Mr. Gravis to have effective control, this is not as clear-cut as the prosecution has presented. While defense has shown that a de facto position is not decisive in and of itself to prove effective control, furthermore, the only task Mr. Gravis actually carried out in accordance with the case facts in paragraph 11 is the setting up of a counter-terrorism campaign to protect the citizens of Hanutan's right to life, which is in accordance with the European guidelines on counter-terrorism. Furthermore, he fulfilled his duty to protect his citizens, and this is not substantive, and the prosecution's claim is not substantive enough to prove effective control. Moreover, the prosecution claimed that by Mr. Gravis's power to issue orders, his capacity as a military commander, and it established effective control. However, defense would like to point this chamber's attention to the appeals chamber held in the Halovich case, in which it stated at paragraph 243 that a superior's authority to issue orders does not automatically establish that a superior had effective control over his subordinates. Furthermore, prosecution has negated the fact that Mr. Gravis's orders were disregarded and they were not complied with. In creating the counter-terrorism campaign, Mr. Gravis included the international human rights standard of necessity and limited the measures that needed to be taken to that was in the interest of national security and the protection of public order. The kicking of pregnant women, the shooting of Castilian men, and the sexual exploitation of young girls were not necessary to achieve the aims of this campaign. Subsequently, the NDS, the SPG, and the police acted beyond the scope of Mr. Gravis's directives, and as a result, did not have effective control. Furthermore, this shows a break in the chain of command and illustrates and satisfies that the indicator of a lack of effective control set out in the 2016 trial chamber 3 case of the prosecutor versus Jean-Pierre Bemba-Gombo. Finally, the prosecution has alleged that Mr. Gravis's utterances in paragraph 10 of the facts is enough to show that there was an ideology carrying through. However, prosecution has negated the 2013 Kralik judgment at paragraph 240, where it was stated that influence alone is not enough to provide for effective control or to make one criminally liable. Furthermore, as my co-counsel has stated, these statements were redacted and cleared up in a press conference, thereby illustrating that this is not indicative of effective control nor an ideology. Judge President and Your Honors, defense has proven that Mr. Gravis did not have effective control, and as a result, defense does not have to prove that Mr. Gravis knew or should have known. Regardless, defense moves to the second argument that Mr. Gravis did not have actual knowledge. The prosecution has alleged that Mr. Gravis should have known on the basis of the IHRD reports and the social media images. However, as stated in the 2013 Lubanga decision, The NGO reports, which relied on heavily by the prosecution in that case, and in this case before the chamber today, are not the fruits of a full and proper investigation. Furthermore, the 2018 Bemba appeal stated that social media images lack probative value and they are weak. This court should not rely on this as evidence for what Mr. Gravis should have known. Furthermore, the aforementioned, yes, Your Honor, Harbour.
Thank you, counsel. Could I just ask a follow-up question from that? I understand your questioning the probative value of the social media reports and the IRHD report. But what would you say to the prosecution argument that at the very least, these should have put the accused on notice and he had a duty to then follow up?
Your Honor, I do see my time has elapsed. Would the chamber grant me an extra 45 seconds to answer your question?
Yes,
Magnificence. Magnificence. Judge, Your Honor, Harbour, in relation to what Mr. Gravis should have known and the prosecution's claim that Mr. Gravis should have been put on notice, I would like to direct this chamber's attention to the separate opinions from the 2018 Bemba appeals by the presiding judge, Judge Christine van der Weijhardt and Judge Howard Morrison, wherein they stated that when there is contradicting information, it is merely not enough for a commander to allege that he did not believe the source. However, if a commander has genuine concern or reason to doubt the accuracy of a given source of information, it absolves him from the standard. As proven, the IHRD reports and the social media images are not a viable source of information, and subsequently, the duty to be informed does not arise from this. Judge President and Your Honors, defense prays that the chamber find this case inadmissible, that the chamber does not have jurisdiction. Judge Worsnop, do you have a question for me?
I do. I'm conscious the time has run out, so if the president doesn't mind. Thank you very much. Yeah, so I just have one question regarding the defence's position as to the mens rea applicable in this case with regard to individual criminal responsibility under Article 28, either A or B. Your co-counsel at some length made submissions about Mr. Gravis's specific intent to commit genocide. Now, you have talked about the mens rea under Article 28 being known or should have known. Could you just clarify the defence's position? Is your position that the relevant mens rea is simply that you, counsel, put forward? Or is it the position that Mr. Gravis's specific intent is also a material element? Thank you.
Thank you, Judge Worsnop, and thank you, Judge President, for providing me extra time to answer Judge's question. Defense would like to apologize for the misconfusion, or the confusion rather, but would like to state that the mens rea that my co-counsel has raised is in relation to intent and the fact that Mr. Gravis did not have the special intent to commit genocide. Furthermore, in terms of Article 28B, Mr. Gravis did not have the material ability to prevent the crimes, nor did he have the knowledge, along with a lack of effective control. As a result, Article 30, the mens rea, is not applicable to us in terms of Article 28. Thank you, Judge President and Your Honors. Defense takes their leave of the court. Sorry, Judge President.
Yes, thank you now for rebuttal. First, for the prosecutor, so you have now the floor up.
Good morning, once again, Mr. President, Your Honors. I will first like to present a clarification on the question that one of Your Honors asked my co-counsel about the causation for the duties. And in the Bemba confirmation of charges decision, paragraph 424, the chamber is of the view that the element of causality only relates to the commander's duty to prevent the commission of future crimes. Having that cleared up, I would now like to present 3 points of rebuttal, each of which will address the defense's prayers. The first point of rebuttal is regarding admissibility, and the defense's claim was that there is evidence of probative value proving national investigations. Note, however, your honors, that defense has not referred to the complete evidentiary standard as per the Gaddafi admissibility decision, paragraph 54, which is, and I quote, evidence of sufficient degree of specificity and probative value. Therefore, they have not addressed the fact that this evidence should be sufficiently specific. And this evidence might relate to the merits of the national case, such as the interviewing of witnesses or suspects, documentary evidence, forensic analysis. It may also include directions and decisions issued by the authorities in charge of the investigations, internal reports, updates, etc. We have none of this information, Your Honor. Yes, we have tangible proof of evidence. However, it is not specific enough. And defenses argue that they will have evidence, and yet they're unable to furnish it before this court. Therefore, it fails the first limb of the complementarity test, and this case should be declared inadmissible. And the defense's arguments on the willingness and ability of the Republic of Hanatus are not applicable to this case, because we know from, again, the Gaddafi admissibility decision, paragraph 89, that only if the first limb of the complementarity test is fulfilled, then the court will move on to the second limb, namely the assessment of the ability or willingness of the state. Moving on to our second point of rebuttal, it is regarding jurisdiction, and the defense has claimed that the admissibility of evidence, namely the IHRD report, should be assessed at this stage of the proceedings. However, Your Honors, first of all, I'd like to remind you that there's no mandatory exclusionary rule in the Rome Statute or the rules of procedure, rules on procedure and evidence. And furthermore, in the Mamburshimana case, a decision of confirmation of charges, paragraph 44, a wholesale assessment at this stage of the proceedings was deemed as it would cause an unjustifiable delay of the proceedings, and it would give rise to an inappropriate predetermination of evidentiary matters, which should be properly decided in light of the whole of the evidence presented at trial. Therefore, we should not assess the admissibility of the IHRD at this stage of the proceedings. Furthermore, the defense has claimed that crimes did not occur within the jurisdiction of the court because Mr. Gravas did not have the requisite genocidal intent. However, Your Honors, this was not our submission. We submitted that his subordinates had the requisite genocidal intent and carry out the relevant conduct with such intent. Therefore, because the defense has not contested the genocidal intent of his subordinates, crimes have indeed occurred within the jurisdiction of this court. Moving on to our final point of rebuttal, on command responsibility, the defense has claimed that the prosecution has failed to prove that Mr. Gravas' effective control over his subordinates. They have claimed that the mere belonging to a chain of command is not per se effective to show, is not per se sufficient, to show effective control, as stated in the Kordich and Cherkez judgment, paragraph 369. We agree with the defense that indeed a mere belonging to a chain of command is insufficient to prove effective control. However, the defense has neglected to address the numerous other factors indicating effective control per the Bemba judgment pursuant to Article 74, paragraphs 188, that we have proven that are fulfilled by Mr. Gravas. We refer to paragraph 417 of the Bemba confirmation of charges decision, which states that effective control is more of an evidence. Oh, I see that my time has elapsed. May I please conclude? Briefly.
You have not time. You have still time, I think.
Oh, okay. Apologize. Which states that effective control is more of a matter of evidence than substantive law. And Mr. Gravas' position within the chain of command is illustrated by the case facts 1 and 11, where he very clearly had effective control. And taken together with his ability to issue orders, as well as his representation of the ideology and the actual task, we see that he did have effective control. Therefore, we have proven that Mr. Gravas had effective control over his subordinates. Thank you for your attention. This concludes the rebuttal of the prosecution.
With the leave of the presiding judge, could I ask one question? I'm mindful of the time.
I think for rebuttal, so we may not raise a question asking, I think so, according to the rule, right?
If that's your decision.
Okay, then for defense counsel, please.
Apologies, I was muted, Judge President and Your Honors. Judge President and Your Honors, defense has 3 points of surrebuttal. First, regarding the admissibility. Second, in relation to subject matter jurisdiction. And third, in relation to effective control. First, the prosecution claims that there is no probative value from the investigations ongoing in the Republic of Newton's military court. However, they have misled the court based on the situation in Libya, on the decision on the admissibility of the case against Islam Gaddafi, the 31 May 2013 case in paragraph 122, where a finding that the domestic authorities are taking steps to investigate the person's responsibility in relation to the same case as the one before the court would not be negated by the fact that upon scrutiny, the evidence may be insufficient to support a conviction of the domestic authorities of the person being investigated. It is on the defense to prove the inadmissibility of this case. However, as previously stated, the investigations do have a start date, they do have an end date, and there is a probative value of Mr. Gravis being criminally held responsible for his actions. The start date is the 3rd of November 2015. The investigations are set to end in the August of 2022. And that basis alone, the chamber should find that there is probative value that the investigations are of consequence and are being investigated. Second, in relation to the prosecution alleging that we have required the subordinate intent. However, this is flawed and must be rejected because with regards to the subordinate intent, as previously stated in the situation in Darfur, Sudan, on Prosecutor versus al-Bashir on the 4th of March 2009 decision on the prosecution's application for a warrant of arrest against al-Bashir in paragraph 152, the chamber held that the mental state, the intent, of the mid-level superiors and the low-level physical perpetrators is irrelevant. And for that purpose of determining whether there are reasonable grounds to believe that the crime of genocide against an ethnic group has occurred. And further, in pointing this chamber to Prosecutor versus Kirstig, the judgment of the 2nd August 2001, the trial judgments in paragraph 549, where the chamber emphasized the need to distinguish the individual intent of the accused and the intent involved in the conception and the commission of the crime. The prosecution has misled this court in focusing on the wrong specific intent. It is Mr. Gravis's intent which we must establish, and he did not have the specific intent. And further, that should we take the prosecution's argument at its highest about the IHRD report, Mr. Gravis's intent was not for 200 Castilian men to be shot and for there to be a famine. Mr. Gravis's intent was to quell the CNF terrorists and to restore public order to ensure that the threat by the CNF terrorists was mitigated. And it was not on Mr. Gravis's intent for the actions to span from the counterterrorism campaign that had a threshold for the political group. Third, the prosecution has stated that they have proven that Mr. Gravis had effective control on the basis that Mr. Gravis's ability to issue order, his formal position, and Mr. Gravis perpetuating an ideology. But this should be disregarded in its entirety because prosecution has misunderstood the defense's argument. Defense has stated that the 2016 Bemba case at paragraph 189 noted that a formal position is not decisive in establishing effective control. Further, defense has already shown that Mr. Gravis's orders were not in relation to the actual tasks he carried out. The counterterrorism campaign established is not enough to show effective control on the basis of issuing orders. The ICTY case of Kordic and Cervec at paragraph 421 used in the aforementioned Bemba case determined that it is necessary to look at the substance of the documents and whether or not those orders were acted upon. And on that, defense submits that there was no effective control, that this case is inadmissible and there's no jurisdiction.
Thank you. Then, so we judge retire in the deliberation room. So maybe we are ready to move on, right? Okay, so first of all, so thank you very much for your strong and clear pleading. So we would like to announce now our decision. So first, the winning team is the prosecution. Congratulations. And first best speaker is Ms. Fakirova, so from the prosecution. And the next, the second best speaker is Ms. Mutoni from Defense Council. That is our decision. Anyway, so congratulations for the pleading. And good luck for the next session.
Thank you, Mr. President.
The International Criminal Court is adjourned. You may now leave the courtroom.
Thank you.
Thank you very much.
Thank you very much.